So in fact, I am thankful to Mr. Ajay. He is immediately after being free from the court has rushed to the office and he has joined. So good evening, friends. In the series of the matters regarding various topics of the income tax on which we were having the Zoom meetings. Now today our topic is the violation of principles of natural justice in assessment and appeal proceedings and remedies available for the same. And the speaker today is Mr. Ajay Vohra, Senior Advocate. He is a leading authority in tax matters. He is also a chartered accountant. He has been practicing for the last 41 years. And he has appeared almost every bench of the tribunal and every high court and obviously for the Supreme Court. There is hardly any matter, important matter before the Supreme Court or before high courts in which he has not appeared. He has not represented the SSC. So his contribution in development of jurisprudence on the direct tax laws is immense. And for the last so many years, he was designated in, I think, 2014 as a senior advocate. And since then, he has appeared in very large number of cases, I'll say. And he has been awarded various positions in the by the various international authorities and as well as domestic authorities. He has been the chairman of International Fiscal Association India branch. He has also been the chairman of the Direct Tax Committee of the PhD Chamber of Commerce, and he is on the board of so many large companies, industrial houses of India. So I'm thankful to Mr. Ajay Vohra for taking this responsibility on our request to be a speaker today on this important topic. So thanks, Mr. Ajay Vohra, for joining us and being the speaker on this. Please welcome. Now I'll request the president of the AIFTP, Mr. Narayan Jain, to give his opening remarks, and then we'll hand over to Ajay Vohra without wasting any much time. Thank you, Jain Sahab. Please.
जैन साहब अनम्यूट करिए प्लीज।
जैन साहब अनम्यूट कर रहे हैं आप।
हमारी इस कमेटी के चेयरमैन श्री वीपी गुप्ता जी और लर्नड स्पीकर अजय वोहरा जी, और अजय वोहरा जी को बुलाने के लिए बहुत दिन से डिमांड थी। जब आप कलकत्ता पधारे थे एक दूसरे प्रोग्राम में, तब भी मैंने रिक्वेस्ट किया था, तो इन्होंने हाँ किया था कि ठीक है। मैंने कहा था वीपी गुप्ता जी आपसे डेट फिक्स कर देंगे जो आपका कन्वीनियंट होगा, तो इमीडिएटली एग्रीड। एंड वी थॉट दैट a subject like principles of natural justice and its applicability in the income tax matters, that will be very relevant. Why I felt relevant? Because I myself had argued many cases taking help of the cases relating to natural justice, and way back 25 years ago also this case is celebrity case, the Dhakeswari Cotton Kishanchan Chalaram, and thereafter, so far this presently the reopening of cases and all these are concerned, so many matters went to the various high courts, and on the basis of violation of principle of natural justice, the high courts were pleased to give relief. And recently, yesterday only, Honorable Justice B.R. Gawai also pronounced a judgment about the bulldozer action. There also the undercurrent, if you properly see, is only the principles of natural justice, that opportunity should be given to the affected party before demolishing the house. So, natural justice principle, though many people may be thinking that this is not a direct subject relating to income tax, but that directly helps us in income tax matters. So therefore, all of us should take benefit of these principles
Ajay.
of natural justice.
Ajay.
And our learned speaker, Shri Ajay Vohra ji, he will be sharing his vast knowledge on this subject, and we all will be happy to listen to him, and I would not like to take your more time. I once again welcome you all. We are about, Sir Ajay Vohra ji, we are about 100 persons, 96 to be precise, attending this webinar, and more may be joining. And those of us who have joined, they will, I'm sure, will take full benefit of this, and they will spread what we are learning from Ajay Vohra among their own people. With this, I once again thank you very much. And our past president, Sri Ganesh Purohit is also with us, and many senior members, office bearers, Sri R.D. Kakra, Secretary General, Deputy President, Samir Jani is with us. So we welcome you all to this webinar, and I once again welcome Ajay Vohra ji, and I also take this opportunity to acknowledge the efforts of Sri V.P. Gupta ji, the chairman of Direct Tax Committee, who has been organizing a number of webinars. And even after today, we will have more webinars for the benefit of our members. So thank you very much. Welcome, sir.
I may just mention Mr. Ajay Vohra has prepared a presentation and slides have been given to Mr. Ravi at AIFTP. So Ravi will be running the slides in coordination what the Mr. Vohra will be advising. Mr. Ravi? Mr. Ravi? Yes, please.
Yes.
So
Please.
thank you, VP sir, for the kind words of introduction. I was wondering, why violation of principles of natural justice, which is such a beaten topic. But as was introduced by Mr. Narayan Jain, I think in the bulldozer action case, I think, as you pointed out, sir, the Supreme Court also referred to observance of the due process of law. So this question of natural justice is inherent in almost all quasi-judicial proceedings, starting with, so far as relevant to us, assessment, adjudication, appeals, and so on and so forth. So I think the topic is evergreen, and as Mr. Jain pointed out, we see the use of these principles of natural justice in any and every matter that is today before the courts or before the tribunal. Sir, but I must say that on your side, there has been violation of principles of natural justice because you never gave me a chance to say no to your invitation. You assume that you have extended an invitation and I have said yes, and I think I fell into that trap without following the principles of natural justice. So friends, I think natural justice is inherent in every proceeding, even if the law does not specifically state for provision of opportunity of hearing, the courts have held and read into the provision a requirement of adequate representation, a requirement of adequate opportunity of hearing to be given to the aggrieved party. So let's go into this question of what is actually natural justice. We often hear of, every other day violation of principles of natural justice, that in an Article 226 petition, assessees move the courts saying that the action needs to be set aside because it has violated principles of natural justice. So let's go to the root of what is natural justice. So may Ravi request you to put up the first slide, please, on evolution of natural justice. Kindly come to the next slide. So natural justice is derived from the Roman phrase "jus natural," which means natural justice, and "lex natural," which means natural law. This is a common law doctrine which is equivalent to, if we must mark this, procedural due process, having its roots in principles of fairness, reasonableness, equity, and equality. I think this natural justice is the bedrock of a fair, transparent judicial delivery system. And I think it is necessary to be observed by every authority involved in that process of assessment and adjudication of disputes, insofar as to ensure impartial justice being dispensed by the system. Come to the next slide, please. So in the Roman law, we have two fundamental aspects of natural justice. Nemo judex in cause sua, which means no one should be made a judge in his own cause, which is implicitly meaning rule against bias. So you can't have the assessor and the assessor becoming the adjudicator. You can't have a system where the CIT appeal, and in our practical life, you have a situation where the CIT appeal has passed an order adverse to an assessee, and the CIT appeal tomorrow becomes the CIT-DR in the tribunal to defend his own order. So that would be a situation where the adjudicator become a judge in his own cause, and that would be a situation where he needs to recuse from representing the department before the tribunal. So this is intended by what is meant by no one should be made a judge in his own cause. I remember a situation where the commissioner had issued a notice under section 263, and thereafter we had gone in a writ to the High Court. The High Court set aside the matter, saying that the commissioner would then deal with all your objections which were before the High Court. And that was precisely our case, that the commissioner can't be made a judge in his own cause. He proceeded to issue the notice. Now that notice was against all canons of law, and that was one of the grievances projected before the High Court, that sending us back to the commissioner would amount to making the commissioner a judge in his own cause. The second principle under the Roman law, which is audi alteram partem, which we often hear spoken of, that no one should be condemned unheard. Simply put, it means that adequate opportunity needs to be given to an assessee in this kind of situation to be able to make out his case, to be able to meet the case that has been set up against him, to be made aware of the material information details that are sought to be used against the assessee, and given adequate opportunity, and thereafter he should be heard with respect to his defense with regard to the allegations that are raised against the assessee. So audi alteram partem is an extremely fundamental principle and the bedrock of a fair judicial system. Subsequently, the third rule, which is also now important, is a party is entitled to reasons for the decisions adversely affecting his rights and interests. So therefore, the adjudicator, whether he's an assessor or he's the appellate authority, must come to a reasoned decision. The decision must incorporate the basis or the foundation on the or the reasoning on the basis of which the assessor or the adjudicator has come to a particular point of view. I think Mr. VP Gupta was following my case in the High Court just now, just before I came here, where the assessment has been completed. We had challenged the 148 proceedings. The court allowed the draft or the assessment to be completed and hence that the assessment, if adverse, would not be given effect to. So in that challenge to the 148, the revenue pointed out that assessment has also been framed. So the court looked at the assessment and came to the conclusion that there was absolutely no basis set out by the assessing officer for coming to the view that he had come to in the assessment order. And the court said, you need to spell out the reasons. And therefore, being on the back foot, the Revenues Council pleaded before the court that the matter may be set aside. So what is sought to be emphasized is a reasoned decision is necessary to be given by the adjudicating authority. A reason which is shorn of, a decision which is shorn of all reasons cannot be sustained by the court. And therefore, a reason without application of mind will certainly not pass muster with the courts or the tribunals. Let's come to the next slide, Ravi. Next one, page 3. I think, yes. So these are now subsidiary rules which are also equally important, and you will see the use of these principles in various courts. One is the rule of hearing, which is opportunity of effective pre-decisional hearing. And this you would have seen is held by the courts to be an important principle of natural justice, that a party must be heard and must be given adequate opportunity to present its case. If you remember the old Sahara case and Rajesh Kumar case in the context of reference to special audit, at that time the provision did not contemplate an opportunity of hearing to be given to the assessee before the special audit was ordered. But the Supreme Court held that natural justice has to be read into the provision even if it was conspicuous by its absence. Subsequently, the law was amended, 142(2)A was amended to make it mandatory to provide a pre-decisional hearing. So this principle today is extremely material and important, that there must be an opportunity of hearing, even if the provision does not provide for an opportunity of personal hearing or an oral hearing, then in that situation, it is still incumbent upon the adjudicator to make available that necessary opportunity for the assessee to present his case. And you would have seen this in the context of the faceless assessment, where the assessing authority took the view that the law does not require them to provide an opportunity of hearing or to give a virtual hearing or a personal hearing. Despite the absence of such a provision in the statute, the courts came to the conclusion that it is extremely material and an important principle of fair and impartial decision making, that due opportunity of hearing is provided to the assessee. And in that situation, where there was lack of opportunity being provided to the assessee, it was held that there was violation of principles of natural justice, and therefore the assessment or the appellate procedure had to be set aside. The further subsidiary rule, Wednesbury principle, which you would have seen in many Supreme Court judgments, this phrase is coined. This is a protection against irrationality, that an arbitrary, irrational decision cannot be sustained. A decision which defies the principles of law or is contrary to principles of law, is against common sense or against logic, that decision cannot be sustained. So the principle says that protection against irrationality, which is a decision which is outrageous in its defiance of either logic or morals, such that no sensible person could have arrived at that conclusion on proper application of mind. So this is again a subsidiary rule of the principles of natural justice, which is invoked in order to point out that the decision which is completely arbitrary, whimsical, irrational, cannot be sustained and therefore needs to be set aside. Can we come to the next slide? Further subsidiary rules is rule of prudence. And the test is, what would a man of ordinary prudence do in such circumstances? So a reasonable standard of conduct under the circumstances, based on what was known or should have been known at that time, a decision was made, or the action was contemplated. So when you look at, when you draft a 260A appeal, you talk of perversity. So perversity is a decision which is reached which no reasonable person correctly informed of in law would come to, or it would be against all standards of prudence. A decision which is imprudent, which is irrational, that cannot be sustained, that would be violative of principles of natural justice. And doctrine of proportionality, again used largely by courts, that one cannot use a cannon to shoot a sparrow. So the decision or the relief has to be proportional to ultimately the charge or the defense that is set up. So these are important subsidiary rules which are ingrained in the principles of natural justice, which are used by the courts in order to do substantial justice between the parties. Next slide, please. I can do no better than read what Justice Pasai has coined in this judgment of Canara Bank versus V.K. Avasti on the meaning of the word natural justice. I'll read a few lines. If you can see from here, the adherence to principles of natural justice, this is in the middle of the paragraph. The adherence to principles of natural justice, as recognized by all civilized states, is of supreme importance when a one second. I think we have to come back. When a quasi-judicial body embarks on determined disputes between the parties, or any administrative action involving civil consequences is an issue. Principles of natural justice are those rules which have been laid down by the courts as being the minimum protection of the rights of the individual against the arbitrary procedure that may be adopted by a judicial, quasi-judicial, and administrative authority while making an order affecting those rights. These rules are intended to prevent such authority from doing injustice. So these are important illuminating observations made by Justice Pasai in this judgment, which is actually the fundamental principle dealing with impartial justice and dealing with observance of due process of law in coming to a decision. So the decision maker is required to strictly, scrupulously adhere to the principles of natural justice while rendering a decision in either a quasi-judicial proceeding, or in an administrative decision. So again, we cannot minimize, we cannot belittle the importance of principles of natural justice in decision making, be it at any level. We can come to the next slide, please. So these are some sections of the Income Tax Act. I already mentioned about the reference to special audit. This is now specially ingrained in this provision. Section 143(3), where it requires the assessing officer to frame the assessment after taking into account the evidence produced by the assessee, after giving the assessee an opportunity of hearing, and after due application of mind. So here, assessment can be faulted if the assessing officer proceeds to complete the assessment A without confronting the assessee with material collected which is adverse to the assessee, and without providing the assessee an opportunity of fair and adequate hearing, or the assessing officer does not take into consideration the evidence that is submitted by the assessee, seeks to ignore the evidence without dealing with the same, so it will not be a reasoned decision. On all these factors, the assessment can be faulted as being violative of principles of natural justice. Section 144(b)(6), Roman 7 and 8, again, pre-adjudicatory show cause notice and personal hearing to be granted prior to bearing return income. And I think from our point of view, a personal hearing that is granted or an opportunity of being heard that is granted will help cut unproductive litigation, which is bound to happen if the assessing officer is to, on his own ipsy-dixy, on his whims and fancies, make an assessment, make an adjudication without taking into account the submission made by the assessee, without taking into account the material placed on record by the assessee, or without providing the assessee an opportunity of hearing. Equally, now this is embedded in section 148A, dealing with the new reassessment regime, where it is now incumbent upon the assessing authority to issue a notice under section 148AB after collecting material and evidence that is available to him, confront the assessee with that material, obtain a reply from the assessee in terms of 148AC, duly examine the reply, and then come to a reasoned decision before rejecting the submission made by the assessee and before proceeding to initiate the reassessment proceeding under section 148 by issue of notice under that section. So principles of natural justice are explicitly and implicitly ingrained in the provisions in different provisions of the Income Tax Act. In some cases, the section specifically provides for an opportunity of hearing, even if the requirement is conspicuous by its absence. The courts have held it incumbent upon the decision-making authority to actually provide an opportunity of hearing before coming to a reasoned decision. The next page, please. These are similar other sections dealing with the powers of the appellate authority, the CITP under section 250. Under section 254(1), again the ITAT is bound to hear both sides, both the revenue and the assessee that are litigants before the tribunal. Notice of hearing is sent by the CITP by the tribunal to both the sides, and thereafter opportunity of hearing provided to both the sides present before the appellate authority, and thereafter a decision rendered after hearing both sides. So natural justice is therefore implicit, inherent in appellate proceedings, both before the CITP as also before the tribunal. The next slide, please. So these are some cases that I have highlighted. Of course, there will be many, but I didn't want to multiply too many authorities. These are illustrative cases that a proper show cause notice is required to be issued to the assessee so that the assessee can meet the precise charge against the assessee. So this is one judgment that I have referred to, Vohra Security Services versus Government NCT of Delhi. Another one, the full bench of the Delhi High Court in JT India Exports versus Union of India. So if you see the application of this principle in the context of the current 148A regime, courts have held that if the 148AB notice seems to refer to some information which is sought to be used against the assessee and which, according to the department, is in the nature of information suggesting escapement of income, it is necessary for that authority to outline that information in the notice, to make available that information to the assessee so that the assessee can effectively rebut the case set up against the assessee. And in a situation where the charge in the 148 AB notice is subsequently abandoned and the 148 AD order is not passed on a completely different grounds, the courts have paused the proceedings initiated under section 148 because the assessee was not put to notice. Section 148 AB is effectively meant to put the assessee to notice of the precise charge against the assessee. And now the entire procedure incorporates statutorily the GKN principle, which was there under the erstwhile regime of 148, where notice under section 148 was given, reason was supplied after the assessee filed a return. The assessee could file objections, effectively dealing with the reasons recorded, and then after the assessing officer was required to pass a speaking order dealing with the objection of the assessee. So a proper show cause notice is extremely relevant for the adjudication of proceedings under the income tax as well. Another example, section 263 notice. Now the Supreme Court has held that it is not a jurisdictional notice. So there is no requirement of issuing the notice like a 148 notice to assume jurisdiction. You have to issue the notice, but that is not necessary for assumption of jurisdiction. But at the same time, what the Supreme Court held in Amitabh Bachchan Corporation, that if an issue has not been put to the assessee, either in the notice under 263 or in the course of proceedings under that section, then in that situation, that particular issue cannot find mention in the ultimate order that is passed under section 263. And that's on the basis that the assessee must be put to notice, the assessee must be given a chance to effectively rebut, respond to the allegation or the charge made against the assessee that the assessment is erroneous and prejudicial to the interest of revenue on a particular issue. So these are instances where a proper show cause notice is extremely necessary, material, and mandatory in order to sustain the proceedings. Then the opportunity of oral hearing is what the courts have said is mandatory if the assessee seeks that specific opportunity by making a petition or making a request in writing or orally. There have been many instances where courts feel that you can file written submission and an oral hearing is not necessary. What the courts have said, this is the Automotive Tires Manufacturing Association, that a written submission is no substitute for oral hearing. So an oral hearing is mandatory. It can be supplemented by written submissions summarizing the oral submissions canvassed at the time of hearing, or the written submissions can precede the oral hearing. But one cannot substitute for the other, one cannot be an effective discharge for the other. So an oral hearing is necessary, mandatory. It can be supplemented with the written submissions if required by the assessee or if considered necessary by the court. But written submission by itself cannot take away the right of or an opportunity of oral hearing. Then effective hearing, you must have a situation where the parties have been heard to their satisfaction. Of course, it does not mean that the litigants can continue to address the court ad infinitum. The court would provide them adequate and reasonable opportunity of hearing. The court should not cut short arguments in such a manner that the assessee is not satisfied with the opportunity granted. But at the same time, that does not mean that the assessee has the leeway to continuously address the court for any length of time or for an indefinite period. So hearing essentially should be a real and genuine hearing. There must be notice given to the assessee in advance of the date of hearing. The assessee must be adequately represented and must be effectively heard at the hearing in order that there is due compliance with this principle of natural justice. Can we come to the next slide? So fairness in action, if we use this in our context, you may have a situation where the appeal is heard by or submissions are heard by one party and a third authority seeks to write the order. Clearly, that would not be in consonance with law, because the law requires that the party which or the authority which hears the matter is the authority which should decide the particular uh, adjudication, the proceedings pending before that authority. So, in a situation where, let us say, proceedings are before the assessing authority are continuing, and in the midst of those proceedings, the assessing authority is transferred, the successor authority would necessarily be required to issue notice, come up to speed with the proceedings that have taken up thus far, and thereafter pass an order. The assessing authority who comes and takes the place of the preceding assessing authority, the incumbent, the fresh incumbent, cannot merely on the basis of record seek to pass an order, uh, holding that I have already taken into account the submission that have been placed by the assessee on record. So that in my view should not be the position. Equally, in the context of section 148, courts have said that you cannot have a situation where the notice under section 148 is issued by one authority, and the reason recorded were by another other authority. So this would ensure fairness in action, and this is, I think, seen in everyday life in our practical experience. Reasonable opportunity, I have dealt that effective opportunity means adequate time to be given. If an assessee is handicapped for genuine and bona fide reasons, it is incumbent upon the authority to grant reasonable time for the assessee to make effective submissions and adequate representation before that particular authority. So in this context, you have several judgments where this principle has been applied, where the assessee, let us say, was undergoing medical treatment, was not able to respond to the notice in time, or the notice did not give adequate time for the assessee to file the details that were called for. The details being voluminous could not be filed within the short time that was allowed. All these are instances where the court would step in and say that there has been violation of principles of natural justice, since the time that was allowed in order to make representation was not adequate. That inadequate and insufficient opportunity granted to the assessee would violate the decision-making process. So these are instances. I'm not going into case laws. I think all of us are aware of these case precedents, which are used day in and day out in order to assail any assessment or appellate proceeding where there is violation of principles of natural justice. Next slide, please. This we've done. No, the next one, page 10. We went back to 8, yeah. I think Mr. Jain referred to the Keshwari Cotton, Kishan and Chelaram, that this is incumbent upon an authority to confront the assessee with all material that is proposed to be used against an assessee. So if the assessing officer has information which has been collected from extraneous sources, which is adverse to the assessee or is sought to be used against the assessee, it is mandatory for the assessing officer to confront the assessee with such information, allow the assessee adequate time to respond to the allegation, and to place further material on record to rebut the allegation that is made, or to contradict the information or the material that the assessing officer has collected in an ex parte manner. So, if you are aware that in the Supreme Court judgment in the case of Puran Mal, it was held that while a search may be declared invalid, the material collected during an invalid search can be used against the assessee. But that is subject to the caveat that such material must be put to the assessee. He must be given an opportunity to rebut the material, and he must be allowed adequate opportunity to make representation qua that material that is placed on record by the assessing officer. Equally, in the context of cross-examination, of course, courts have differed, but I think fundamentally what has been held, and this is, I have just referred to one judgment in Andaman Timber, where it is said that an ex parte statement recorded at the back of the assessee, if it is sought to be used against the assessee, the assessee must be given an opportunity to cross-examine the deponent. And only then can that statement be used. But I would add a word of caution here that the assessee must plead on record that opportunity should be given to cross-examine the witness of the deponent whose statement is sought to be used against the assessee. In the absence of a request being made, the courts have held that it is not mandatory incumbent upon the authority to make available the witness for cross-examination. And if the witness is offered for cross-examination and the opportunity is spurned, the statement of the witness is accepted at its face value. If it is adverse to the assessee, it will be certainly used against the assessee based on the inference that the adjudicating authority would want to draw from that statement. So, opportunity of cross-examination is an important principle, part of the principles of natural justice, in order to sustain an assessment which is based on ex parte material collected by the assessee. In fact, the courts have gone to the extent of holding that where the witness was not offered for cross-examination, then in that situation, the ex parte testimony of that witness has to be excluded from consideration. This is the Delhi High Court judgment in Sona Electric, which was again reiterated in several other cases. So, important principle on cross-examination of witnesses, which is part of the principles of natural justice. Can we come to the next page? So, absence of pre-judge mindset. This is, I think, often practiced in the breach, where the principle is clear and explicit that the authorities should decide the case with an open mind and not prejudge the guilt of the assessee. I think in everyday life, you come across situations where many of us come out of the court saying that the judge has already pre-decided the issue, he was not willing to listen, and that the hearing was an empty formality. In theory, yes, the principle is clearly that the judge must come to the court with an open mind, hear the arguments on both sides, and then decide the matter. He should not have prejudged the issue before he actually heard the party. So this is an important principle. Now, in order to challenge a decision on the ground that it was made with a prejudged mind, I think important that material is placed on record to show the conduct of the judge, which would establish that the judgment was rendered with a prejudged mindset. Extremely difficult, but I think this is just a principle. Then reasoned order, I have already dealt. A reasoned decision must reflect the basis and the foundation for coming to a conclusion. So that is important, that the mind of the judge is reflected in the judgment. How the judge came to a particular decision must be borne out from the reasons that are spelled out in the order itself. The order must speak for itself. So that is important, that there is a reasoned order passed by the assessing authority, the adjudicating authority, in order that that can be effectively challenged, and the mindset of the judge can be deciphered from the reading of the order itself. So if you see now in the context of a 263, of course, 263 there is a statutory provision which says that if the examination of record reveals that the assessment order is erroneous and prejudicial to the interest of revenue, the department's case invariably is that the assessment order is a 1.5 2-page order. It does not reflect that the assessing officer conducted inquiries on issue A, B, C, D, that he took into account any material or evidence placed by the assessee, and the assessment order does not seem to reflect application of mind on these issues, and hence the order is erroneous and prejudicial to the interest of revenue. Inquiries that were due to be made have not necessarily been made. Now, those are often charges that one sees in 263 proceedings. But there, the proceedings can be challenged on the ground that section 263 opens with the word where examination of record, and record would include the notices issued, the responses furnished, any order sheet entries, and so on and so forth. And therefore, in that context, the courts have held that on issues on which the assessing authority agrees with the assessee, those are normally not reflected in an assessment order. So merely because the assessment order is short, it's cryptic, does not mean that those particular issues that are subject matter of the 260 the proceedings have not been examined or have not been gone into by the assessing authority. So a reasoned order is extremely material in order to sustain the validity of that order, in order that further proceedings, like I mentioned, the 263 proceedings against an assessment, a reasoned assessment order can be successfully defended. Equally, if there is a reasoned order, past assessment order, a 148 proceeding on a change of opinion can be successfully assailed, saying that the order reflects application of mind on a particular issue, and hence, on a change of opinion, the subsequent action cannot be sustained or cannot be upheld. So those are the basis for the courts and the authorities to pass a reasoned order, in order that the order can be sustained in further proceedings under the particular statute. Then kindly come to the next page. So these are the remedies that are available against violation of principle of natural justice. First is the statutory remedy. Of course, the statute provides for an appeal or any other remedy. For instance, you may even file a revision against an assessment order. So statutory remedy in terms of an appeal revision against the order suffering from infraction, that is of course available as a matter of right. Extraordinary remedy in the form of a writ before the High Court under Article 226. Normally, the courts are loath to entertain a writ petition on the ground that you have an alternate statutory remedy. There are exceptions to the rule, and violation of principles of natural justice is an accepted exception to the bar of alternate remedy. So the courts, if they are satisfied that the particular order which is subject of challenge in the writ petition suffers from violation of principles of natural justice, the court will entertain the writ petition, strike down the assessment order or the particular order, and remand it for fresh consideration. So I have seen this debate and this dilemma that whether the court should really quash an order which suffers from violation of principles of natural justice, or should set aside the same in order to cure the irregularity, set aside to the stage where the irregularity occurred, and thereafter the authority may proceed to pass a fresh order of de novo adjudication uninfluenced by earlier proceedings. I would tend to tilt to the view that violation of principles of natural justice does not by itself establish the infirmity in the order such that such violation is fatal to the validity of the assessment order or that particular order, rendering such an order non-est or invalid or illegal in the eyes of law. I would think that whereas such a violation takes place, the courts can restore the proceeding to the stage where the violation occurred and direct the authority to continue proceedings from that stage. So that's my view on the relief that would normally be available in a situation where there is accepted violation of principles of natural justice. So those are a few of my comments on this much debated, beaten subject of violations of principles of natural justice, which is used day in and day out in almost every and any kind of proceeding before the courts, before the adjudicating authority. So I will hand over back to Mr. VP Gupta. Mr. Narayan Jain will be happy to take any questions that may be raised.
Dear Mr. Vohra,
Right.
before coming to the question answer, may I request you to further elaborate on two aspects?
Right.
Although to some extent you have covered the set aside matter or the questioning of the matter, but in most of the cases, as you have seen, the courts are inclined to set aside the matter. So in those cases, the assessees are suffering a lot because they have to again go through the process.
Right.
And in many circumstances, the case should be, say, approval has not been properly given.
Right.
A court says that you go again, he will consider the matter. As in 263, you have given an example. If he has not considered the proper submissions or proper things, or in 264, he has not passed the proper order, then again the matter will go to the same authority and he is. So in many circumstances, So where is the line we can draw that in when matters the court should quash this or where it is to be set aside? One is I request you to kindly further throw light on this. Another thing I just wanted to point out to you that section 148 and 148A have been amended by this Finance Act. The old sections were providing, say, subsection section 148A, clause 1A was saying that he will further firstly investigate or go through the information, whether it is worthwhile or whether it gives any reason to escape assessment or not. Now that clause has been removed and straightway on the basis of information, he can issue the notice on that. Secondly, in that section 148A, earlier there have been time limits. He will give the notice at least for 7 days to the SSC. Now that time limit has been removed. Similarly, he was supposed to pass the order within 30 days. Now that time limit has been removed. In section 148, earlier the return was to be filed within 3 months. Now there is no time limit. He can give you any time up to 3 months. So what is your view on these amendments and why these amendments and how far they will give the further rise to these principles of natural justice?
On the first point, frankly, I have not been able to decipher a bright line where you can say that the order should be quashed or the order should be set aside. But if you look at precedents, I would think maybe 90+% would tilt towards setting aside the matter to the stage of irregularity. I have seldom come across cases where the order may be quashed on principles of natural justice. So unless there is a gross irregularity which cannot possibly be cured, for instance, I remember an old case where opportunity of cross-examination was not given. Now the witness did not appear on at least 3 or 4 occasions. The assessee appeared on every occasion on which cross-examination was fixed. Then it was learned that the witness had died. Now in that situation, obviously, you could not have cross-examined the witness who was no longer, alive. Now in that situation, I think there would have possibly been no other alternative with the court but to quash the assessment on the ground that there was violation of principles of natural justice. So I think I would tend to take the view that a case of quashing would be rare. It will depend on the peculiar facts of the case, but the inclination of the courts is to largely set aside the matter where there is violation of natural justice that is alleged. Coming to the second point, I think on the 148, the time limit, as you can see, has been reduced from 6 years to 5 years. And there is no further extension of time up to 10 years in such cases and all. While the information that suggests escapement of income will be the basis for reopening, I would think the courts will still read into the amended section 148 the requirement of adherence to principles of natural justice. That will still be required. That material must be confronted. It is not on the ipsi dixi of the assessing officer, merely on the basis that some information has come to his possession, that he can seek to proceed. He can seek to proceed and reopen the assessment or issue a notice under 148. I would think the court will read that into the amended provision. I hope I have answered your point.
Yeah, thank you very much. Prohit sir, will you have any comments?
Sir, there is a question. Can you take up?
Sir, actually, the
Sir.
changes those have been made in law. It is because there had been a lot of litigation on these issues. So government basically wants to avoid litigation. See, if 7 days time is not given for filing reply, then we used to challenge that in a writ petition. And if 7 days time is not given, the court will remand the matter back. Similarly, if the material is not supplied, again, they will remand the back. That is why in the recent amendments, they have made it compulsory to give the material along with the show cause notice. It has been made mandatory to provide the material. And then that 7 days time limit, though, has been removed, but as rightly pointed out by respected Ajay Vohra sahab, that court will still take cognizance of it and they will see that reasonable time is being allowed. Same is the position of filing of the return. In one of my cases, I have seen that the law says that 3 months time should be allowed. Now, the AO has allowed 97 days time. So what is the position? Is it illegal or it's not illegal? So I have challenged that. I say that he has power to allow only 90 days. He cannot allow 97 days without approval from the commissioner. So these technical issues, they want to avoid and avert so that litigation is reduced. That is the intention. The intention is not to debar you from the reasonable opportunity or anything. I think Mr. Vohra has given very elaborate discussion on this issue. And then there are, but Vohra sir, there are many judgments to say that cross-examination is not compulsory.
No, I agree, sir, but I think, as I pointed out, there are differing views on the issue. But at the same time, if you look at the latest decision from the Supreme Court in Andaman Timber, that, according to me, makes it mandatory for affording an opportunity of cross-examination if you seek to use the ex parte testimony of a witness against an assassin. I think after Andaman Timber, I would think that this is almost mandatory to confront the assassin and provide the assassin an opportunity of cross-examination. If the assassin
Sir,
seeks that opportunity, yes, of course, consequences will follow.
So there is one situation that in 148A B notice, in reply, the assessee said that he would like to cross-examine the person whose statements have been recorded. Now the question is, this is a preliminary notice.
Right.
Those, in my view, that opportunity of cross-examination will come at the later stage. At this stage, I don't think the AO is required to give cross-examination facility, because if the material is sufficient, material is available with the AO, he can certainly reopen the assessment. And that cross-examination can be said that it will be given when you come in the regular assessment. Because these are summary inquiries in 148 AD. They are not supposed to be detailed inquiry. If it is detailed inquiry, then yes, cross-examination is mandatory. But in summary inquiry, I don't think that the cross-examination will be mandatory.
So I fully agree with you. At the stage of 148 ABE or 148 AD, he has to come to a prima facie belief.
Sir.
So therefore, there does not have to be conclusiveness qua that belief that he has formed. So therefore, as you very rightly pointed out, the cross-examination will be given in the course of assessment. So you cross the threshold of validly initiation of proceedings. If in the assessment you fail to give that opportunity of cross-examination, then other consequences that follow the assessment can be faulted on that ground, or the addition can be deleted on that ground.
Right, sir.
Right.
Thank you, Gupta ji.
My point, my query, if doctrine of natural justice is not followed, then there are two situations. One is doctrine is incorporated in the act itself, and other is it is not incorporated. How does it make difference in these situations? How is it different if it is incorporated and if it is not incorporated?
Sir, if it is incorporated, I think it is statutory mandatory for the authority to follow the principles of natural justice. Like I gave you the example of, we have this 142A reference to special audit. In the old time, before the amendment, the Supreme Court in Sara's case and Rajesh Kumar said that an opportunity of being heard before you made a reference was necessary. Subsequently, the law was amended. Today, the section incorporates the requirement of giving opportunity of hearing. But even if such an opportunity is not implicit in the provision or is not explicit in the provision, the courts will read into the particular provision in the statute the requirement of adherence to principles of natural justice, which will mean an opportunity of being heard.
So should we interpret that there is no difference in these two situations?
Yes, it is possible to interpret. Yeah.
Sir, if doctrine of natural justice is not followed, assessee has to unnecessarily spend money in litigation. Why should assessee not be compensated for that?
Sir, today I think you can see there is so much unproductive litigation. I don't think we can go into the question of the assessee having to litigate for no rhyme or reason. But I think that's how we are presently faced with completely unnecessary, frivolous litigation that is happening.
Sir, my question, Vohra ji, regarding this so-called notice, we often encounter situations where in so-called notice has been issued on X amount or X issue, but they pass finally out of the Y issue or include some other issues. So whether these notices are also to be set aside for reconsideration or should be order should be quashed on these or those editions should be deleted. What is your view?
My view is technically they should be quashed. You see, it shows no application of mind. You
Yeah.
issued the 148 AB notice on a particular information. Now you have on a 148 AD, even if the amount is different, is on a different issue. But
Yeah.
this relief actually differs from judge to judge.
Yeah.
There is nothing written in law, nothing cast in stone.
Any precedence is there, sir?
Sorry?
Any precedence is there? So-called notice has been issued on X amount, X issue and Y issue has been added and has been quashed.
Sir,
Yes, yes,
as I mentioned to you, I think Gupta ji will bear this out.
yes.
In the previous round in Delhi High Court, the judge took serious note of this difference in the amounts in the 148 AB and the 148 AD, or difference in the name of the parties in a 148 AB and a 148 AD, and quashed the proceedings.
Yes.
But presently, I think all that they seek to do is set aside to say that the assessing officer may consider your reply and then pass a fresh order under 148 AD. It differs from judge to judge. I think you can't possibly
Thank you. Thank
point
you.
any particular provision. Yes.
It has been held that where the order has been passed to the D on different aspect or this new aspect has been taken, then it has been quashed.
No, but Gupta ji, I was doing a research for one of my
Yes.
matters.
Yes.
I could find only 2 cases where
Hmm.
this was quashed. Otherwise, it is quashed and set aside.
I'm
For that
right
to
with
pass
that.
on.
Yeah, that's okay.
Uh,
So set aside to hey, that's right.
right.
समीर जानी सर कुछ आपके
सर एक
कमेंट्स
क्वेश्चन मेरा
कहना
भी है
चाहेंगे?
सर। आई हैव अ क्वेश्चन सर।
Right,
एक मिनट समीर जानी प्लीज।
Sir, as you rightly said, Gupta ji,
जी
148, the reasons recorded or the basis for 148A, if it is found to be erroneous, then would the reopening be quashed or once again, like 90% cases, set aside? Vohra ji.
Sir, if according to me, left to me, if the reason does not exist, I don't see why another innings should be given to the assessing officer. Actually, it should be quashed. If the assessing officer has the time, he may issue a fresh notice, but the court should not give that liberty. But in practical experience, I am pointing out that normally courts are inclined to set aside the matter rather than quash the proceeding.
Right.
Mr. Bimal Garg, you're wanting to ask something?
Yes.
Please.
Can you elaborate something on service of notice and natural justice? Most of the notices are sent through mail these days.
Right, sir.
And there are certain issues of returning of the post also, but the same is not mentioned and the ex parte assessments are passed.
Right.
This is a gross violation as I understand in regard to natural justice. So what shall be your take up?
No, so basically, see, service of notice can assume different forms, or let us say a service of assessment order. Now, there is no requirement that the order must be served within the limitation period.
Notices are not being served.
Okay, so if the notice, it is mandatory to serve the notice. Now, if the notice is not served and maybe the time fixed for compliance has already elapsed, then in that situation, there will be violation of natural justice. The assessee has not been given adequate and effective opportunity of hearing.
But the issue is that the courts are inclined to set aside the matter. That is
That's only set aside, yes.
That's the problem.
Right. Then they will not quash the proceeding.
Any other question?
Thank you.
Right.
Anybody else?
My question,
Please.
is it not arbitrary on the part of the court? In some cases it is set aside and in some cases it is quashed.
Right.
If
Largely
principle is not followed.
set aside, I think let's take it largely set aside. if it appeals to the sensibilities of the court that there has been gross violation which affects the validity of that proceeding, the court may quash. But I don't think you can fault the court for that reason.
Sir,
Jain Sahab?
Ajay Vohra Sahab,
Ji.
we must thank you for enlightening us. Basically, sir, we have seen that if the matter is set aside to the AO or even to the CIT appeal, say in case of income tax appellate tribunal, then those revenue authorities, they are inclined to repeat the same order.
Right.
So that is the biggest issue, because they do not, even if there is some direction from the tribunal
Right.
to look afresh, give the evidences and all this, they hardly do it. So that is the problem. But in some cases, the Honorable Calcutta High Court and the Income Tax Appellate Tribunal, Calcutta, they have held that the second inning need not be allowed to the department, and they have quashed that matter.
Right.
But I agree that it depends from case to case and from court to court or tribunal to tribunal. But then this is a big issue that the revenue authorities continue with their own mindset,
Right.
which is very difficult, because they are the revenue authorities and they are afraid that some action can be taken against them if some relief is granted, even despite the tribunal's order. Because tribunal is not saying that you go this way or that way. They are simply setting aside that, okay, you look at the submission or the arguments of the taxpayer.
Right. Right.
This is the problem which I think the government need to look into. Of course, they talk of the new amended act, but even I have my doubt that the amended act means whatever provisions are in favor of revenue, those will be implemented, and whatever is not in favor of revenue, those will. This is what I think.
Right.
Thank you, sir.
Thank you.
Anything else? Anybody else? No.
If you have some free time, I will give 1 minute laughter on natural justice. Second opportunity. Assessment was 148 was quashed and department filed second appeal. Then assessing officer wrote in his file that CIT appeal is wrongly quashed, and because of that income chargeable to tax has escaped assessment. Therefore, I am issuing 148. And he made same addition again.
Sir, I want to ask one thing.
I
Am I
think
audible, sir?
Yes, yes. Please, your name?
Sir, it is myself, Pramod Himatsingka from Calcutta.
Yes, please.
Sir, regarding the officer billwell, we have judgment without the incriminating material. If the assessment is not pending, no addition can be made. But the Guwahati tribunal had decided the matter in the angle of the 150, on which the Supreme Court has refused to entertain whether it is they sought direction from the Supreme Court that the direction should be incorporated in the order. But Supreme Court refused. In spite of that, Guwahati High Court, Guwahati Tribunal, Income Tax Tribunal, has passed an order that in view of the 150, this is notwithstanding anything, the 149, the government, the revenue can proceed for 148 actions. However, it is justified, sir, although Delhi High Court judgment is there. Just now we have got it. So we seek your opinion, sir.
No. So basically, you see, you are probably referring to Abhisar Bildwell.
Yes.
Abhisar Bildwell did not provide the revenue with the latitude to proceed against the assessee under section 148, where no incriminating material was found. The department had moved a review petition. The Supreme Court rejected that, converted it into a miscellaneous application and rejected that, saying that we cannot give the liberty to the department to proceed under 148. There was a subsequent Supreme Court judgment in UK Paints, which also took the same view. Now, your precise issue has been dealt by the Delhi High Court. The Delhi High Court, in the case of Orchid and another case that I had argued, has elaborately dealt with Section 150 and held that this is not covered within the ambit and scope of Section 150, and therefore the assessing authority cannot assume jurisdiction under Section 148 to seek to reassess the income for that particular assessment year, where the department failed on the ground that the addition could not be sustained in the absence of incriminating material. So the Guwahati tribunal has gone wrong. According to me, it's contrary to law.
Now, what is the remedy to the SEC concern? Whether he should approach to the tribunal or he should approach to the High Court?
No, you should have to file an appeal to the High Court only. The tribunal is not, in a miscellaneous application, not deal with the matter.
So nice.
Okay. Thanks a lot. Nice presentation. Now, may I request Mr. R.D. Kakra, Secretary General of AIFTP, to give a vote of thanks, please.
Friends, at the outset, I like to first thank our chairman BP Gupta साहब, जो कि इस वर्ष पूरी श्रृंखला के अंदर में वर्चुअल वेबिनार के जरिए हम सबको लाभान्वित कर रहे हैं. साथ ही साथ हमारे नेशनल प्रेसिडेंट जो कि बराबर इस ओर ध्यान देते हैं. Undoubtedly, I like to thank today's 3P participant, Mr. Pramod Himasinka and Mr. Pransuka and Mr. Pawan Vaid, जिन्होंने आज के इस डेलिब्रेशन के अंदर में अपना योगदान दिया. No doubt, the man of the match. The today's session in natural justice, undoubtedly an extraordinary, beautiful and superb presentation by PPT and valued deliberation by Vohra Sahab. We all are benefited. Salute to Vohra Sahab. Friends, natural justice is a common man law, but it's a very vital one. The important section as per Constitution who safeguard us are Article 14 and 21 and Section 21 of General Clauses Act 1897. Friends, there are 7 Saptapadi principles of natural justice. Saptapadi principles. Whenever you find an order of assessment order or appellate order, first you search where is the violation of principal justice. The principles of natural justice are audi alterum pattern, nemo judex in causa, third, bias and impartiality, fourth, fair hearing, 5, regent decision, 6, opportunity to produce evidence, 7, right to cross-examination. Friends, I sum up all these 3 and undoubtedly agreed 100%, fully agreed with Vohra Sahab that in the eye of law, violation of principles of natural justice make the assessment order honest and void. I have pleasure experience of natural justice last fortnight because I get a benefit of 70 crores from NFS CIT appeal order only on the basis of this principle of natural justice. 70 crores for 4 years are involved and 70 crores order demand is vacated. Only there is 25 lakh demand is there. And I filed for that tribunal and where I will get the benefit. To say something, 4 लाइन कहना चाहता हूं. ससैया के दोहरे जो नाविक को तीर देखन में छोटो लगे, ये असली तो है घाव करे गंभीर लेकिन प्रभाव करे गंभीर. इसको आप पढ़िए, प्रभाव करे गंभीर. तो मित्रों सबको धन्यवाद देते हुए ये कहना चाहता हूं कि आज का जो सेशन है बहुत लाजवाब और शानदार रहा. वोहरा साहब को हम सब तालियां और सब सैल्यूट करते हैं इसके लिए और आगे भी उनसे बेनामी लॉ और उसके ऊपर तो सुनना चाहेंगे और वोहरा साहब हमें अपनी सुविधा के हिसाब से समय देंगे. धन्यवाद. Over to Chairman Sahab.
Thanks a lot, Mr. Ajay Vohra, Senior Advocate, for your deliberations today. And it is okay. Thanks a lot. Everybody is, we are obliged, highly obliged.
To my senior colleagues.
Okay, meeting comes to end.
Thank you. Thank you, sir.
Thank
Good
you.
evening.
थैंक यू सर। वोहरा साहब को नमस्कार, बहुत बहुत धन्यवाद वोहरा साहब को। अनिल जी कुछ बोलेंगे क्या?
नहीं सर, बस आपको थैंक्स में ज्वाइन कर रहा हूँ सर। मैं तो गुप्ता साहब को सलाम कर रहा हूँ सर।
नहीं साहब, नहीं, थैंक यू वेरी मच, थैंक्स अ लॉट।